There's at least one appellate court that thinks they can do nationwide injunctions concerning birthright citizenship or anything else. It's the Ninth Circuit Court of Appeals. We've got our first court of appeal that has rebuked Donald Trump and found that his executive order trying to rip away birthright citizenship for those babies that are born in America because their parents are of indeterminate immigration status or are here temporarily. They have denied that. They are the first appellate court, and for good measure, they've taken the lead and they've issued a nationwide injunction, finding that even the United States Supreme Court has found that in order to give complete relief to the states, and the states are the primary plaintiffs in the case, they've got to do a nationwide injunction. You can't have a baby born in Wisconsin be a citizen and a baby born in Louisiana not be. And this goes hand in glove with a ruling in New Hampshire that has held the ring and held the pin for the birthright citizenship order. That's why we haven't been reporting on it being exercised. Babies that have been born so far have been United States citizens. I'll break it all down for you. And it was 2-1. Of course, there was a Trump appointee. I've been before this Trump judge before. He was part of my panel in an appellate argument I made about a year ago, Judge Bomate. I'll talk about what his decision was, but 2-1. Where it matters, the Ninth Circuit Court of Appeals has now sent this case on a fast track to the United States Supreme Court, and I'll break it down for you right here on an explainer here on Legal AF and on MeidasTouch. Okay, let's get to it. Did I introduce myself? I'm Michael Popok. I got so excited I might have forgotten to do that. All right, let's dive in. I've got the decision right here in my hand. How did we get here? The first temporary restraining order issued against the Trump administration, if you can even remember, because there's been almost 1,000 of them now. The very first one, 5 days into the administration or so, was issued by Judge Kafenor in Washington State, Seattle. He said in his entire 40-year career, he's never seen a more obvious constitutional violation than the executive order trying to rewrite the Constitution and the 14th Amendment and the Citizenship Clause, which came out of our Reconstruction civil rights period to reverse a racist decision by a then United States Supreme Court we refer to in the law as Dred Scott, that said that children of freed slaves were not citizens. 14th Amendment, we've seen the movie Lincoln. Tells you all about how these amendments got passed, including the 14th Amendment and the one I'm going to talk about. Any open question about whether the parentage of the child born on U.S. soil mattered to the citizenship determination was settled in 1898 by a case called Wong Kim Ark coming out of the United States Supreme Court that declared once and for all that as long as the person was subject to the jurisdiction of the United States, in other words, regulatory jurisdiction, you get pulled over for a traffic stop, you litter, you murder, you commit crimes on immigration law. We're watching Donald Trump demonstrating every day that these people, regardless of their immigration status, are subject to the laws of the United States. He's chasing after them with federal troops through factories and farms and schools and churches and the streets. They are obviously subject to the regulation, but for Donald Trump, that's not what that means. What he wants the 14th Amendment to mean is that if they are born of parents who have allegiance or came from another country, those children have allegiance to that other country. He focuses on political jurisdiction. That's not what the 14th Amendment says. 14th Amendment says subject to the jurisdiction of. There are only two classes of children who are not U.S. citizens under the 14th Amendment. Those, based on Supreme Court precedent, those that are born to U.S. diplomats, okay, because they're living, they're like diplomats living on foreign soil within the United States. The French embassy is considered French soil. So those children born even if they're born at a New York hospital or whatever from the UN, those children are not citizens of the United States, can't claim citizenship. And the second one is children born of enemy combatants who are in the United States, like during a war. And I mean during a war. Like if Japan in the World War II made its way onto mainland America, or the Germans did, and one of their participants gave birth, that person would not be considered a U.S. citizen. Makes sense. And how does the Ninth Circuit know that? Because they went back to historical precedent and analysis, going back to the creation of the 14th Amendment and the laws that preceded it. We had a Citizenship Act that preceded by several years, and the 14th Amendment fixed some of the terminology. The other big argument that was adopted by the dissenter, Judge Bomate, is that the states don't have jurisdiction. But there's a case in the last several years, Biden versus Nebraska, where the United States Supreme Court said point blank that if a state has its population will be diminished by a ruling of the federal government, like head count, they have standing to argue against that interpretation or that law. And that's what's happening. The states are like, these are U.S. citizens. And Trump's saying they're not. So you can't count them. We're saying we're taking them out of, we still have to provide them services, but you're not giving us federal funding. So that whole issue gives standing. What's standing? It is the fundamental requirement that a party come to court has an actual live injury that they can then try to get redress for in the courts as part of a dispute resolution mechanism, because we don't want courts giving out advisory opinions. We want live cases and controversies. So standing is a term of art, a doctrine that's used by courts. They always evaluate whether the parties in front of them have standing to be there. Now, the United States Supreme Court, even though about a month ago, just at the end of June, said we're not going to touch birthright citizenship, the merits, we'll leave that to the appellate courts. Well, the Ninth Circuit's the first appellate court. But we don't want nationwide injunctions except in very limited circumstances, and we're really not going to tell you what they are, but we don't want trial judges issuing nationwide injunctions unless they certify a class and then do an injunction on top of it, which is what happened in New Hampshire, or they left open the door on states. If states need, in order to give them complete relief under the complete relief doctrine, you need to do a nationwide injunction, then maybe it's okay. And now the Ninth Circuit has said, okay, we take you up on that. We find that in order for the states that are now before us, Washington, Illinois, Arizona, and Oregon, to get complete relief, we're going to have to do a nationwide injunction. So in New Hampshire, just to compare it, the federal judge there certified a class, I think there's 22 states up there, and issued an injunction. Ninth Circuit said Judge Coffenor was right, the one who said this is the most egregious example of constitutional violation I've ever seen in 40 years. And his nationwide injunction was right because they read the language of the June 27th decision by the Supreme Court to mean that if there's a state involved and you need to give complete relief to the state, that a nationwide injunction may be appropriate.
Hey everybody, Ben Meiselas here from the MeidasTouch Network. I wanted to let you know about my podcast partner, Michael Popok's new law firm. It's called the Popok Firm. Michael Popok's pursuing his dream of starting his own law firm, really based on the popular demand by all the Meidas, Mighty, and legal AFers who are approaching Michael Popok with their cases and saying, can you help us? And at that time, Popok was not able to. So he went out on his own. He started the Popok Firm, where he is now handling catastrophic injury cases like car accident cases, trucking cases, malpractice cases, big negligence cases, wrongful death cases. So if you or someone you know have a case like this, the consultation with Popok's firm is free. Give him a call, see if you have a case. It's thepopokfirm.com, thepopokfirm.com, or you can call 877-POPOK-AF, P-O-P-O-K-A-F. So 1-877-POPOK-AF. Give Michael Popok a call, and I'm really proud of you, Popok. Thanks for all the hard work you're putting in.
Boom. We have our first nationwide injunction on top of our first decision by an appellate court on the merits, the meat of the issue. Now, Judge Bomate, who's a Trump appointee, because the decision was written by Judge Gould, who is a Clinton appointee, joined by Judge Hawkins, who was an Obama appointee, and of course the one, which one of these things not like the other one? Judge Bomate. I've been in front of Judge Bomate. I think I've been in front of Judge Hawkins too. I mean, I found him to be thoughtful. My issues didn't really raise political consequences, so I didn't really get to see his full Trumpiness on it. But his argument was, well, the states don't have standing. It's premature for us to rule right now. Let's kick the can down the road. Now, fortunately, the New Hampshire class action injunction has been holding up Donald Trump from imposing the law. I think they're still moving on coming up with the procedures they're going to use to order states to deny federal protection, coverage, and citizenship, because that's what this is all about, to the children where parents are undocumented or here temporarily. You don't like birth tourism? Go change the Constitution, and good luck with that. But this is what is in our Constitution. It is sacrosanct. It can't be taken away by political purpose, through political purposes. Let me just read to you from a couple of pages of the decision that matter. So on page 3 of the order, they say the 14th Amendment was adopted after the Civil War in order to reject and refute the holdings of Dred Scott versus Sanford from 1857, a Supreme Court case, a racist one at that, which in substance held that slaves and descendants of slaves were not citizens of the United States. And the reason for the 14th Amendment was to put citizenship beyond the power of any government unit to destroy. Is that exactly what Donald Trump is doing? Page 4, when the 14th Amendment was ratified, whether birthright citizenship applied to the children of non-citizens was still an open question, but the Supreme Court answered that question in Wong Kim Ark, a case from 1898. That's where Chinese nationals in the United States were excluded from citizenship, another racist policy, by an actual statute. And Chinese laborers who left to try to come back in were denied re-entry. Let's be frank, Chinese laborers, forced laborers, slaves who were brought to this country against their will and human trafficked, built a lot of the railroads and did a lot of the farming in this country, especially out west during the late 1800s and early 1900s. But Wong Kim Ark, he was a child born in America of Chinese parents. He left to visit China, then tried to come back, and he was stopped and denied entry. And the United States Supreme Court said, he is subject to the jurisdiction of America. His parents might be Chinese nationals, but he is subject to the laws of America. And held that the Citizenship Clause stands for the fundamental rule of citizenship by birth within the dominion of the United States, notwithstanding the alienage of the parents. We don't look to the parents, we look to the birthplace of the child. That's been going on since 1898. They then totally took apart the argument that the states don't have standing, using the case I told you, the Biden case from a couple of years ago, where they're losing people. And by losing people, that means they're being injured. Plus, there are other people involved in the case on the plaintiff side. There's parents, there's mothers, some of which have given birth already, some of which are about to give birth already, so they can always prosecute the case. So on balance, what do we have? Boiled down. Preliminary injunction, nationwide injunction supported by the Ninth Circuit, quoting the Supreme Court of the United States from the June 27th decision, sticking it to Donald Trump and saying he's wrong, of course, on the 14th Amendment interpretation and the language of subject to the jurisdiction of that he's using to try to push his anti-American views of immigration and birthright citizenship down our throat. What happens next? Donald Trump will likely, and I'll come back on the air and do another hot take an emergency application, everything's an emergency, up to the United States Supreme Court. I'm not sure it's an emergency application, though. Since the New Hampshire case has been in place, he has not taken an emergency application. And it sort of is undercut, any argument of emergency is undercut because he hasn't moved on the other injunction. So he may not do an emergency injunction. If he does, Justice Kagan makes the decision. By tradition and protocol, she'll roll it over to the full 9, the en banc of the bench. They'll make the decision with further briefing and oral argument maybe over the summer. But we're already so late into the summer, and with October 1st right around the corner, which is the new term, I think the emergency application thing is not going to work or not going to happen, and they just do it a traditional writ of certiorari. But Donald Trump loves emergency applications because he gets limited briefing, he gets the ideological scatter, right? He gets the right-wing MAGA, Kavanaugh, Gorsuch, Alito, Thomas, sometimes Roberts, all over to the right, and everybody's in their respective corners, and he gets a 6-3 vote in his favor. So he sees an advantage to exploit the shadow docket. So if he does the emergency application, I'll come back and report on it. If he doesn't do it, I'll come back on and report on it. You're here on the MeidasTouch Network. Hit the subscribe button here and come over and help us. Legal AF YouTube. We do 12 new videos a day at the intersection of law and politics. I've got a dozen contributors. I curate the channel as Michael Popok, the founder and co-founder of the channel and of the Legal AF podcast. Take a minute and help us there as well. So until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.